Mr. Jones, you have 5 minutes, sir.
Thank you, Madam Chair, and thank you to all of the witnesses for your testimony. It is so important that we shine a light on this issue because it provides yet another example of how the legacy of Jim Crow continues to harm people of color in this country. The history of the Fair Labor Standards Act is well documented. And as we've heard here today, the exclusion of farm workers, domestic workers, and tip workers in the law was done intentionally to exclude Black workers from the basic pay and worker protections afforded to white workers under this landmark legislation. There is no good reason why, nearly a century later, we continue to have these exclusions in the law. Congress's failure to act upholds a system that oppresses working class people of color, and especially women of color, by the way. That is, in fact, what Congress in 1938 intended. Now, my grandmother was a domestic worker who spent long hours cleaning homes, and she worked well past the age of retirement because she simply could not afford to retire when most people do. Ms. Yoon, you mentioned in your testimony that domestic work was often seen as not real work. How did that perception prevent the fair and full protection of domestic workers under the Fair Labor Standards Act? And do we still hear echoes of this argument today in the debate over extending wage and hour protections to domestic workers?
Thank you for your question, and thanks for sharing your own story. I think, as I've talked about in my testimony, the long-standing association of domestic work as unpaid labor, as women's labor, as labor of Black women, harping back to the days of slavery, and labor of other women of color and immigrant women, I think all contribute to devaluing this labor as unskilled and therefore deemed not worthy of protection and industry standards. I think all the parents and aunts and uncles and grandparents on this committee and my fellow panelists will know that the skills that are needed to raise a child to thrive, skills that are needed to care for your young aging parent who may have dementia, to live with dignity, or to care for a kid with complex medical condition so that that kid could sleep in her own bed, right? All of this takes incredible amount of skill, but we continue to devalue this work. We devalued it back then in 1938, and I think we continue to devalue today. I think the most recent debate about whether care is an infrastructure in our economy as we talk about how we recover our country really speaks to this issue. Our caregiving infrastructure collapsed during the pandemic. 800,000 left the workforce last September alone, and we're back to 1988 levels of women workforce participation. Yet some say, largely men, saying it's not infrastructure because it's not roads and bridges, even though this investment in the care infrastructure will precisely allow not just women, but all parents to go back to work, and that will continue to fuel our economy back.
Thank you so much, Ms. Yoon. And of course, a few days ago, I introduced the Universal Child Care and Early Learning Act with Senator Elizabeth Warren, which would fully provide for universal child care in this country, child care indeed being infrastructure. And I could tell you, what my grandmother did was real work. I know that because I was with her oftentimes when daycare was too expensive. She had to take me to clean homes with her. Now, Ms. Dixon, Mr. DeCamp's testimony seems to question whether the exclusion of farm workers and domestic workers in New Deal legislation and in the Fair Labor Standards Act is rooted in racism. He talks about there being an absence of compelling evidence in his written testimony. What compelling evidence do we have on this? And why is denying the roots of these exclusions so harmful?
Well, my grandmother used to say, when you know better, do better. And we know better. And we have all of this evidence that tells us that these exclusions are harmful, they are unnecessary, and we need to move on from here. And so I think the main thing to understand here is that this argument is rooted in the Commerce Clause, right? To say that in the Commerce Clause, there was no authority to actually put these folks in the Fair Labor Standards Act. But this argument is a red herring because the constitutional justification issue was raised by one senator during a legislative debate over the bill, and that's suspect on its face. The Supreme Court had already changed the interpretation of the Commerce Act by the time the FSLA was passed, so we know that that is just overblown and not accurate.
Okay, thank you, gentlemen's out of time.